Introduction to Intellectual Property Rights, Part 1. In this video, we're going to provide a brief introduction to intellectual property rights with a particular focus on copyrights. Hello everyone, my name is Babak Akhlaghi, a patent attorney with NovoTech IP International, where we secure your assets through intellectual property, IP for short. I am also a co-author of the Patent Application Handbook and a former adjunct faculty at the University of Maryland, College Park, where I taught courses relating to legal aspects of startups. If this is your first time here, please click the subscribe button. The links to everything we will mention in this video are also below. Please make sure you stay until the end, where I'll share a tip on how to protect your copyright. Let's get into it. So what are intellectual property rights? As the name suggests, intellectual property rights are those that are created by intellects, minds. They include copyrights, trademarks, trade secrets, and patents. In this video, we will cover copyrights, and in subsequent videos, we will in turn cover trademarks, trade secrets, and patents. Before we turn our attention to copyrights, let's briefly talk about why intellectual property rights are important. Intellectual property rights are the most valuable assets of any company, but particularly startups, because they can help startups attract investors, raise capital, protect market share by preventing or deterring competitors from offering competing products or services, and even help avoid or reduce the possibility of expensive litigations. With all the benefits they offer, and the fact that they account for most of the value of startups, intellectual property rights should be given the highest priority and must be carefully thought of and protected. However, with so many challenges facing startups, such as, for example, hiring talent, raising capital to keep the lights on, rushing to launch the product to market, and managing day-to-day operations of the company, unfortunately, way too often, protecting IP rights falls on the back burner and is not carefully thought of and protected. And when IP is turned to, it is often too late. With this overview, let's turn our attention to copyrights. What is a copyright? Copyrights protect original works of authorship fixed in a tangible medium of expression. So, what does this mean? It means that to be copyrightable, the work first has to be original, meaning it is an independent creation by its author. Second, the work has to be a work of authorship, for example, an expression. This naturally comes in many forms. For example, it includes literary works such as a book you just finished writing, a song you composed, a poem you wrote, or a painting you drew. Sometimes a work of authorship can have multiple copyrightable portions. For example, in my favorite Eminem song, I'm Sorry Mama, the video, the song, and the lyrics are all protected under copyright laws. Third, the work has to be fixed in a tangible medium. This can include a paper, a CD, a computer, anything that can even temporarily store the copyrightable content and later be used to reproduce it. Registration. There is no registration required for you to have a copyright. A copyright is born as soon as you put pen to paper to write your book, compose your song, or paint your painting. However, registration provides certain benefits. For example, the registration provides an independent third party, U.S. Copyright Office, confirmation that you have a protectable copyright. And more importantly, registration is a prerequisite for bringing lawsuits in federal courts. Duration. For copyrights created and owned by its author, the duration of the copyright is the life of the author plus 70 years. For works made by hire, the duration of the copyright is 96 years from its first publication. For additional information regarding duration of other copyrightable content, for example, for joint works or anonymous works, please see the link provided below. Tip: make sure you provide a proper notice to the world about your copyrightable content, whether it is your website, your software, your song, or your book. Doing so disarms the future infringers from an assertion of innocence infringement to reduce the financial damage they have to pay you. To provide a proper notice, two things are important. First, form of the notice, and second, the location of the notice. As to the form, use the following formula. 1. The symbol C or copyright. 2. The year of the first publication of the work. And 3. The name of the owner of copyright in the work. As to the location of the notice, it should be in a location that can be reasonably seen. So, in another word, it can't be hidden. For example, if you use your website, anywhere on the first page where the notice can be seen is acceptable. Thank you for tuning in. If you like this video, please click the like button and/or place your comments below. I would love to read them.